Good morning, Mr. Cordara.
My lord, good morning.
Before you resume, we have two questions, which are really for both of you, but since you're on your feet, I'll address them to you. Firstly, we have found it not entirely easy to track down what the 9 months claim actually covers. Clearly, the parties know what it covers because they put a quantum on it. And when I say what does it cover, is it where, to use Ms. Mitrofanis's terminology, T1 takes place between January and October 78. In other words, the invoice falls in that 9 month period. Or is it when a debt becomes bad in the 9 month period, whatever becoming bad is, which, as we discussed yesterday, is a slightly amorphous concept. What do you mean by the 9 month period? I mean, clearly, it must mean something precise because Mr. Justice Miles has struck everything else out and left that in, and we need to know what's been left in.
I will answer with a presumption, and then I will.
It's your claim.
Indeed, and the presumption I've always had, but of course that's no guarantee of anything, which is that where Article 11C1 events occurred in that, so stage one of the answer, 11C1 events occurred in the 9 months, and therefore it ought to be the arising of bad debts, even if the supply to which the arising of bad debts gave rise predated the 9 month period.
Oh, so before January 78. So if you supplied in 77, but the debt became bad in February 78, that would fall within a 9 month period, is that?
That is what I have just said.
Yes.
Whether my clients did it that way, I've never asked.
Do you have any idea of, because as I say, the quantum has been agreed, as I understand it. I can't remember the figure, but we were told it was 2% of a 65 million, so it's presumably about 1.3 million.
Slightly more, but yes. The alternative is that they simply applied a broader brush, which would be conservative from the Commissioner's point of view, which would be invoices sent out from day one of the 9 month period. So, and then they would go bad. When they went bad, we would know it's within the 9 month. Well, it wouldn't necessarily be within the 9 month period. Some would have gone bad within 9 months. An invoice sent out halfway through month 8 of the 9 month period would have perhaps only go bad in month 12.
Yes, but would that be an old scheme claim? Or, I mean, I know the commissioners have an argument that all the 9 month periods covered by the old scheme, but we're not concerned with that because they're not running that before us today. But, I mean, that actually posits the question. You send an invoice at the end of July 78, it goes bad in December. You allow 6 months, and after 6 months non-payment, you treat it as bad and you write it off in your accounts.
Yes.
Is that within the 9 month claim or not?
Well,
there must be an answer, and we don't know what it is, and it sounds to me as if you're not quite sure what it is, but I think your junior might.
May I turn around?
Of course.
Thank you. Can you tell me?
Yes.
My junior's going to tell you the answer.
That would be very helpful.
Thank you.
My lord, my lady. In terms of the claim that BT presented, so because obviously it's a number of years after the period in question,
yes.
So post-Fleming, people could make claims going all the way back to 1973. So the revenue published guidance in terms of how people could extrapolate backwards and could estimate claims. You could only estimate.
You've destroyed all your actual paperwork, I take it. You don't. These aren't.
There was some paperwork, so it wasn't
yes.
entirely that everything was dispensed with. It's just that because taxpayers could go back so far, under the revenue's guidance, they accepted the fact that taxpayers may well have destroyed records going back.
Yes.
As it was, BT did have more records. So they were able to look at the historic records, and in terms of actually then calculating the whole amount of the claim, they looked at the supplies right the way through, originally from 1973, but have then since just capped the claim from 1 January 1978.
So that supplies from January 78.
Yes.
So that's where T1 falls after 1st of January 78, to use the terminology.
Yes, I mean, in terms of the legal argument as to what they perhaps ought to have done is a slightly different point, I would say. But in terms of what they did do in terms of quantum, the only way that they could extrapolate back was that they looked at their accounting records to see what the supplies were throughout the whole history. So BT still had those records. They were able to calculate, in particular with this claim, they had a different sector of business. They had their corporate clients that were on one system.
We're not concerned. We're only concerned with retail clients, aren't we?
Yes. So the retail side, they had all the data going all the way back to see what supplies were made, and they then had to determine what the average rate was of bad debts by reference to other publicly available data. And then that was used to work out what the average would have been for the amount of bad debts probably accruing for telephone services during those periods. And that would have covered 1973 probably, well, right the way through, because by the time they put in their claim in 2009, even the most recent periods would have still been 20 years old. So that was what they did. So they looked at their usual accounts, worked out what the supplies were on the retail side. Then they did the extrapolation to work out what the average rate of bad debts would have been, and then that was applied in all those different periods. So, as I understand it, they also then based that on the fact, that was also on the basis of a debt going bad after 6 months.
Yes.
So it followed then the new scheme approach, so whereby when the law was changed, so you have to write off the bad debt, but you also had to wait 6 months before you could actually then make your claim for bad debt.
So I think I've understood that the 9-month claim covers invoices where the supply took place between 1st of January 78 and October 78, and a proportion of those is assumed, extrapolated, to have gone bad. What I've not understood yet is whether it's only those which went bad in the 9-month period, in other words, the supplies from 1st of January to 1st of April, allowing 6 months for them to go bad, or whether it's the proportion, of invoices rendered in the 9-month period which went bad, even if they went bad after October. Do you know the answer to that question?
Because the original calculations were done back to 1973, what they would have done was looked at supplies all the way through and then pushed it forward, as it were, 6 months.
Yes.
So by the time you get to 1 January 1978, you would have been capturing the bad debts, so on the supplies that had occurred 6 months earlier.
Oh, so you
would have been treated as written off after that 6-month period by the 1st of January 1978.
So is the quantum of 9-month claims those which are extrapolated to have gone bad in the 6-month sense in the 9-month period?
Yes.
Yes. So it does capture 6 months worth of invoices supplied before January 78, but which went bad during the 9-month period.
I believe that's how they did the calculations.
Right. Okay. Thank you. That's the answer to our question. That's very helpful. It wasn't, I think, clear from the papers, but it's a lot clearer now. The second question is this. We believe the application which HMRC brought to have been a twin-barrelled application to strike out and for reverse summary judgment. We don't think we've got the application notice, which I think we would quite like to see, and we certainly haven't seen any evidence in support of the application. In fact, we don't know if there was any evidence, either in support or in opposition to the application, which you quite often wouldn't get under a strikeout, but you quite often would get under a Part 24 application. Do you know the answer to that question? Because you were offering to show us evidence, but I apprehended that was witness statements of trial,
Exactly.
not witness statements on the application.
Absolutely. I think we've proceeded entirely on the basis of the legal argument.
Pure legal argument.
Pure legal argument.
But maybe, yes.
I did in the depths of my boxes have. I need to untangle them a little, but I do have a copy of the application and the grounds, and I'll hand those
Do,
up
do
as
you,
soon as
do
I
you think Mr.
untangle them.
Cordara is right? That there was no evidence before Mr. Justice Miles on the application.
No, it's just
It's purely.
setting out our position and then explaining it in our grounds.
I think we would like to see the
I'll hand
application.
those up as soon as I manage to put them
very much.
together.
Thank you,
Sorry.
Mr. Cordara.
Rather
I'm
fundamental.
sorry to have interrupted
Not
you.
at all. So purely by chance, the original answer I gave you seems to have been right,
Yes.
which is that it's only when Article 11C events occurred within the 9 months.
Or
from-
are extrapolated to have occurred on the basis of debts going bad after 6 months, which is a lot clearer than it was. Yes, thank you.
I'm most grateful. What I would propose to do is just to resume, subject to one or two brief remarks, looking at Iveco. The brief remarks are to the effect that the inquiry, which I try and compress as far as I properly can into Iveco, is something which is important for understanding where the law has got to, number one, but it is not critical in the sense that if you're persuaded by my DMG point, then it doesn't matter. And the third point to make is that the automatic or not question, which I say Iveco gives very definitive guidance on, that itself is not essential, I'm persuaded on that, for the same reason, i.e. the DMG reason. If it wasn't automatic, then that would have been a DMG type claim that we mistakenly did not make, and it would feed into both our causation and forbearance points. And the third and final introductory comment, as far as our so-called machinery point, which is a point that links through to the Excel case, which I'll come to, Justice Cockles' decision, that point is somewhat better informed if and when you come to deal with it by understanding the machinery, which is, of course, the Iveco point. So if I can come to Iveco, having reflected overnight, I've reorganized myself into 3 phases. First of all, to show you Lord Justice Newey's conclusions, and those come essentially between paras 41 and 50. The second stage will be to look back at the argument, and that is focused on paras 33 to 36. The reason for that is because in argument there was debate about whether Article 11C had in fact begun to operate in the BT story. So you've got this court reflecting with the assistant counsel on a rather central issue potentially in our case. And then the third stage is the effect of the conclusions in stage 1. That's paras 53 and 54. So coming to para 41, which is page 1426, the cases at divider 54, the bundle. And the gist of what we read here is that there's a debate about how wide the margin of discretion is.
Sorry, which page number again? One.
My lady, it's page 14. I think I gave you the wrong page. 1452. 1452. And at 41, Lord Justice Newey, he records my learned friend's submissions about the Freeman case. He says, Miss Mitrofanous argued that the Freeman's case shows that unless and until implementing legislation had modified the position in a permissible way, a taxable amount is reduced under EU law as and when the price is reduced. Mr. Hitchmo pointed out the issue in Freeman's was whether the taxable amount was reduced in accordance with the UK's implementing legislation, or at an earlier stage. CJEU wasn't dealing with a case such as the present one, where there had been no implementation. While, however, there is some force in that submission, there can, as it seems to me, be no question of the UK having been free to delay substantially the time at which the taxable amount was to be reduced as a result of a rebate. The fact that Article 11C1 provided for the taxable amount to be reduced, quote, under conditions which shall be determined by the member states, end quote, will have given the UK a margin of discretion, but a limited one. And then turning to 43, and his lordship at this stage is extracting key passages from the Kraft food case. He quotes para 26 from that case in these terms. As to whether the principles of VAT neutrality and proportionality preclude such a requirement, it must be noted that Article 90.1 of the VAT Directive requires the member states to reduce the taxable amount and consequently the amount of VAT payable by the taxable person whenever, after a transaction has been concluded, part or all of the consideration has not been received by the taxable person. End of quote. Article 90 is the replacement in the principal VAT Directive of Article 11C1. That passage, and also I refer you to paragraphs 27 and 31 from the Kraft case. He quotes that that provision embodies one of the fundamental principles of the VAT Directive, according to which the basis of assessment is the consideration actually received, and the corollary of which is that the tax authorities may not, in any circumstances, charge an amount of VAT exceeding the tax paid by the taxable person, Goldsmiths. And then at 31, still within the quote, the court has stated that such conditions must enable the taxable person in appropriate circumstances to recover the entirety of the credit arising from that excess VAT. This implies that the refund is to be made within a reasonable period of time. And his lordship then says this at 44. It's apparent from this passage that Article 11C1, as the predecessor of Article 90.1 of the PVD, quote, requires the member states to reduce the taxable amount and consequently the amount of VAT payable by the taxable person whenever, after a transaction has been concluded, part or all of the consideration hasn't been received by the taxable person, and embodies the fundamental principle that the basis of assessment is the consideration actually received, and the corollary of which is that the tax authorities may not in any circumstances charge an amount of VAT exceeding the tax paid by the taxable person. It can be seen, too, that the margin of discretion which Poland enjoyed, because Article 90.1 of the PVD provided for the taxable amount to be reduced under conditions which shall be determined by the member states, was a restricted one and didn't allow Poland to impose conditions preventing a taxable person from obtaining a refund within a reasonable period of time. And then at 46, having moved to the Lombard case, I won't read the whole of 46, but his lordship, about halfway down, 7 or 8 lines down 46, on the right-hand side, there's a sentence starting, there is nothing in the wording. There is nothing in the wording of Article 11C1 to suggest that a reduction in the taxable amount could legitimately be deferred to any great extent. The more so since the French language version uses être reduit in place of shall be reduced, and it would be wholly inconsistent with the precise and unconditional nature of the obligation imposed in 11C1, the fundamental principle that it embodies and the importance of VAT neutrality to allow member states to evade Article 11C1 by delaying a reduction substantially. To the contrary, a refund must be made within a reasonable period of time. Compare para 31 of Kraft. And then 47 is perhaps the core provision, because his lordship then joins up the dots between that and taxpayer conduct. 47, the upshot, in my view, is that it was incumbent on the UK to implement Article 11C by providing for a reduction in the taxable amount at or soon after the time when a rebate was paid. It failed to do so until the end of 1989, but suppliers were nonetheless entitled to rely on Article 11C1 against the UK. It was therefore open to a supplier to, quote, make a negative entry for the relevant amount of tax, to adopt words subsequently used in Regulation 73 of the 89 regulations. In his VAT account when he paid a rebate. If he didn't make such an entry at the time, his right to rely on Article 11C1 will have allowed him to say that each relevant taxable amount should be treated as having been reduced when it would have been if the United Kingdom had duly implemented Article 11C1. In other words, at or soon after the time when a rebate was paid, and on that footing he had made overpayments. I don't see why a supplier's entitlement to rely on 11C1 against the UK should permit him to reduce the taxable amount himself and so trigger a repayment claim years later. There is, to my mind, no reason why an ability to rely on a provision in the implementation of which the UK ought to have provided for a taxable amount to be reduced at or soon after the time when the rebate was paid should translate into a right for the taxable person to reduce the taxable amount himself whenever he chooses, potentially decades later, and at a time when the UK could not have adopted had it duly implemented. It follows that I don't accept the analysis advanced by Mr. Hitchmost. Just pausing, his lordship is therefore therein developing this concept that although a member state has a margin of discretion to delay, and presumably a taxpayer has some practical margin itself to delay, neither of them can stand in the way of the operation of machinery of 11C1. Just pausing, one question, of course, is, well, is this relevant to that part of 11C1 which engenders the current claim, which is the bad debt part, rather than the rebate part? And my submission is that there's nothing in policy terms between the two, in the sense that they're both implementations of the same provision, and they're both expressions of the same underlying fundamental policy of the Act, of the directives. Yes, it is true that Section 12 says in its proviso that the taxpayer shall only be entitled to bad debt relief upon making a claim, and we'll see that in the next segment of the presentation how that was discussed. But it is equally true that Section 80, subsection 2 says, save upon a claim being made, the commissioner shall not be liable. So if anything, the wording is stronger under Section 80, but this court cut through all of that. Indeed, I can't see a reference to Section 80, subsection 2 in this judgment, other than the quote of Section 80, subsection 2, at para 13 of Lord Justice Nugee's decision at page 1443. So this court had before it a purported Section 80 claim situation, and at letter G on page 1443, these words, 80 sub 2, the Commissioner shall only be liable to credit or repay an amount under this section on a claim being made for the purpose. And no doubt the taxpayer was trying to rely on that to excuse its coming to the Fleming process many, many years too late. If I can just complete the small remaining amount to be read under this first segment, that takes one to Section 49, para 49, Lord Justice Nugee, is Roman 2 and Roman 4, para 49. Roman 2 on page 1455.
Sorry, just to interrupt. You say there's no discussion of Section 80, Section 2. Presumably there's no indication that it was argued.
None at all. But
so it wasn't considered?
It was ex facie before the court. There's no record of anyone, perhaps now I'm imposing my own thought, regarding it as sufficiently important to raise it. But the tactical positions of the parties in this case, were different. Commissioners wanted the taxpayer in Section 80, so they weren't going to raise it.
Understood, but also the decision doesn't in a sense, answer the point then, does
No,
it?
it's
Because
silent.
it doesn't address it.
No. So, and it may well be that is all that one can say, but when we come to look at the automatic operation point, then it's a rather interesting position, because, well, for reasons that are obvious, I won't labour it. 49 Roman 2 records this. Mr. Hitchmo argued that the timing of the outcome required by Article 11C1, i.e. the reduction of the taxable amount in the case of a rebate, must depend on the exercise by the individual of their directly effective rights. I can't see, however, why that should be so. The supplier is entitled to rely on Article 11C1 in relation to the period between 1978 and 1989, notwithstanding the UK's failure to implement it. But nothing in Article 11C1 indicates that the taxable person is intended to be able to determine the point at which the taxable amount is to be treated as having been reduced as a result of a rebate, let alone that he should be free to do so many years later. Roman 3, Mr. Hitchmo suggested that it was HMRC's case that Section 8 had served. I'm so sorry, I don't want to read 3, it's 4, forgive me. Roman 4. Roman 3 is relevant. Roman 4, if one looks at Roman 4, it appears from the passage from his first decision, set out in para 17 above, that Judge Bernard didn't consider that Article 11C1 could operate to produce an overpayment, quote, independently of domestic legislation implementing it. If I have understood Judge Bernard correctly, he was of the view that such a consequence could only flow from the domestic legislation that gives effect to the reduction of the taxable amount. In my view, however, the ability of a supplier who had paid a rebate to recover the VAT that he wouldn't have paid if the price had been reduced from the start cannot have depended on a UK introducing provisions such as Regulation 38 or Section 80. Since Article 11C1 conferred directly effective rights, a supplier must have been able to rely on it and to obtain appropriate redress in advance of any implementing legislation, and in fact, regardless of whether any steps were ever taken to implement Article 11C1. Any other conclusion would, in my view, be inconsistent with the directly effective nature of the supplier's rights.
Is it fair to say there's an analogy between what the judge was considering there and the 9-month period? In the sense that there had been no domestic legislation.
Yes.
And as I understand it, the point that we're considering here on issue 2 is not being pressed by HMRC for the 9-month period.
Indeed. So, but on the basis of what I have read so far, it would be the case that during the 9-month period, Article 11C was doing its work, perhaps secretly from all concerned, but it was working. And indeed, working in a manner unfettered by any UK exercise of discretion.
Yes.
Then Section 12 and later Section 22 come along. They have that initial requirement or entitlement upon a claim being made. And in the light of these passages, and there's a little more to come, the question must arise, for how long, if at all, can that requirement to make a claim impede or delay the operation, the relentless operation of Article 11C? One, maybe for a short time, but the suggestion that the absence of a claim over a very substantial period of years by a taxpayer, given the way that Sections 12 and 22 are structured, prevents the operation of Article 11C1 to vest the taxpayer with an accrued right is one that we respectfully challenge on the basis of the analysis that I'm in the course of reading. At some point, Article 11C does its work. whether one can access or what sort of domestic machinery one can access to get the money is a logically separate point. This, what I have just said, is, for obvious reasons, an undecided point, because it wasn't on the table directly, although in Overcoat, although I'm about to show you something which may help. But we say that in the light of your Justice approach, it is the right approach, and at some point in the 20 or 30 years, those rights vested. And this is in part the reason that I showed you yesterday the public notice dated 2017, where the commissioners very properly said, in the wake of BTCA, there may be sums to be paid to those who had claims under the new scheme which they didn't pursue, subject to proof. That was that public notice that I showed you briefly from supplementary bundle 2.
Supplementary bundle 1, document 1.
Enclosure 1 of supplementary 1. That's post BT in the Court of Appeal. But it's March 2017. Iveco was being reached at the Court of Appeal in November 2017. But the Commissioner's arguments in the Iveco litigation, which have obviously gone through the first tier and the upper tier before reaching the Court of Appeal, those had been formulated, I think, probably in 2016. Whether there's a connection, I mustn't speculate. So, Para 50 of Iveco reads this. In short, it seems to me that on the assumption that Iveco paid rebates between 78 and 89 without making adjustments in respect to them in its VAT accounts, it was at once, or at least after the expiry of a relatively short period, entitled to maintain that the relevant taxable amounts should be treated as having been reduced, and accordingly that it had overpaid. That's obviously, that's the end of the first group of citations, and that obviously then, as we'll see, starts the section 80 clock ticking for the purposes of time bar. The second short group of paras.
What is the time bar under Section 80? You've got 4 years.
It's 4 years now. It's
From what?
From the accrual of your right to your refund, and what this decision is
that your right to refund accrued after a short period?
Exactly, irrespective of your own conduct or indeed knowledge. Obviously, there's no mistake dimension at all in the Iveco case. It was just a taxpayer who came very, very late.
You say there was no. It simply wasn't argued.
Well, there wouldn't have been a basis for a mistake claim because.
Well, it's a statutory appeal, isn't it? It's a statutory appeal, isn't it?
It's a statutory appeal, my lady, but no, I was making the broader point. That there's no way that the Iveco story could be presented as a mistake story.
Because there was no implementation at all, so they couldn't have said we thought it had been implemented incorrectly.
No, there was nothing. I mean, they simply failed to climb through the Fleming window by the 31st of March 2009. They can't blame the commissioners for that.
But I don't think mistake is about blaming anybody.
All right. It slips into that too easily.
Yes. But when you get to it, I think we'd like to know what precisely was the mistake you made in the 9-month period.
It's on my
your agenda.
Of course. Absolutely. Then stage 2 is just to dip back into the argument to see what was said to his lordship about how far, if at all, any of the material that I've been reading to you has a read across to the BT story. And the 3 paragraphs there are 33, 34, and 36. So 33 appears on page 1448, hopefully. So this is my learned friend and counsel for the taxpayer in dialogue, in essence, with the court. So at 33, Mr. Hitchmo argued that the upper tribunal recognised in this passage that GMAC couldn't be said to have accounted to HMRC for more VAT than was properly due unless and until a claim was made. Moreover, so Mr. Hitchmo said, the Court of Appeal has subsequently endorsed that view, as to which see para 38 below. That's a reference to GMAC. 34, Miss Mitrofanus, however, disputed Mr. Hitchmo's interpretation of para 184 of the upper tribunal's decision. She attributed the perceived need to claim appropriate relief, quote, to the fact that the upper tribunal was dealing with bad debt relief, which has always depended on the creditors asking for it. In this connection, she referred us to Section 12 Finance Act, which provided for a person to be entitled to a refund on the making of a claim to the commissioners. Section 22, which was in material respects identical. Section 11 of FA 90 and Section 36 of VATA 1994. She pointed out too that the upper tribunal could not have been proceeding on the basis that GMAC would have been able to trigger a reduction in taxable amount at a time of its choosing, since the tribunal could not then have concluded, as it did, that BT's similar claims would be time barred if they fell to be dealt with under Section 80. Had it been the case, Ms. Mitrofanus said, that no taxable amount was reduced until the taxable person claimed, there could have been no question of BT's claims being too late. In all the circumstances, it seems to me that the upper tribunal's decision cannot of itself lend any support to either case. And at 36, Ms. Mitrofanus said, and I think correctly, that these passages, and his lordship, forgive me, I was quoting from BT, 86 and 190. 36, Ms. Mitrofanus said, I think correctly, that these passages are inconsistent with either case, since they implicitly assume that BT's rights accrued when the bad debts arose, not when it put forward its claim in 2009. Mr. Hitchmo, however, emphasised that Lord Justice Rymer's comments were based on no more than generalised discussion. So that we say is an acknowledgement, albeit arguendo, that the BT case can be read, it's not something that this court has to decide, to confirm that in the background, the Article 11C1 clock had indeed started to tick.
Sorry, that is the passages quoted from BTCA are again for the 9-month period, aren't they?
Indeed.
When there wasn't any domestic machinery.
There wasn't. But the earlier passages that I read, which do deal with a member state's ability to introduce lawful conditions, the earlier passages I read this morning,
Yes.
that is to say, between 41 and 50, those were unqualified, and indeed the underlying European cases, Kraft and Lombard, in deciding that a member state could not delay for a considerable number of years the accrual of a claim by any form of domestic legislation or condition. And this is an open question, I accept, which may never arise in this litigation if this litigation even goes forward. But if our interpretation of what Lord Justice Nugee said about the inability of the member state to delay for more than a reasonably short time the actual accrual, albeit at EU law level, of an Article 11C1 right is correct with respect to his lordship, then our rights did go on accruing, albeit perhaps subject to a reasonable delay period from the beginning of the implementation. We say we have a viable argument to that effect if we need it. And we only need it if the court is unpersuaded or a court is unpersuaded of our DMG. The final third and final stage is just to show you 53 and 54, which is a matter of practicality more than analysis. So 53 on page 1456, his lordship says this, the Mitrofanus, of course, did not accept the premise underlying Mr. Hitchens' submissions. Let me just pause. If I can take it up at C, the letter C, insofar as paragraph 53, letter C, insofar, however, as Iveco still had a claim, its remedy was, she said, to be found in section 80. That provision, she submitted, was designed to apply when there had been an overpayment that could have afforded Iveco redress here. She drew an analogy with Birmingham Hippodrome and the Leeds City Council case, each of which proceeded on the footing that section 80 was applicable to overpayments flowing from failure to implement a directive correctly. In the Leeds case, Lord Justice Lewison noted that section 80, quote, is intended to be a complete statutory code for the repayment of overpaid VAT. 54. I've already said that in my view, Iveco was entitled to maintain that the relevant taxable amounts should be treated as having been reduced, and accordingly that it had overpaid even before Reg 7 of the 1989 regulations and section 24 FA 1989 were enacted. That being so, I don't accept Mr. Hitchner's premise. I don't think there's any need to identify a vehicle allowing Iveco to exercise a right to reduce the taxable amount where there had been a rebate before 1990. Its remedy as regards the pre-1990 rebates was to claim to recover overpayments, which it could do under section 24 FA and 1989 and later section 80 VAT Act 1994. Section 24.1 provided for HMRC to be liable to a person who, quote, had paid an amount to the commissioners by way of that which was not due to them. And section 80 contained almost identical wording until 2005. Viewing matters in the way I do, the words were apt to apply. In 2005, section 80 was amended by FA number 2, 2005, but one or other of subsections 1 and 1 capital B, I don't think it necessary to decide which, will then have been available. And on this basis, the Iveco's claim must be time barred in its entirety. It had to be brought by at the latest the end of the selling window in 2009. So I've made my point that the law has been further elucidated. I made the point yesterday that there is no parallel analysis to this in BTCA, but nothing in this is inconsistent with BTCA. BTCA gives Section 80 very narrow view. It may well have largely hobbled its application to situations where the payment's already been made before the event occurs, but it doesn't traverse the ground that we've seen here. There is no Article 11C analysis in BTCA, and certainly nothing inconsistent. The final, very swift point.
Just before you leave that,
Yes.
I understood BTCA to say there was no Section 80 claim. That was the ground on which the cross appeal was dismissed.
Yes. Para 125.
Yes. You wish to say on the basis of either code there is a Section 80 claim because there was an overpayment.
No.
You don't seek to say that.
We lost that argument. Para
Yes.
125.
Yes.
So what I
But you do seek to say there was an overpayment.
do.
But since the ground on which the Section 80 claim was dismissed was that there was no overpayment because all the tax was due, how can you, consistently with that, maintaining this action, which I accept as a separate action, does it not raise the very same issue? Was there an overpayment of tax?
We're not claiming the same. We might be claiming the same amount. We're not claiming the same money. It's the autologic point in para 54, where the court says, reminds itself, says it's Mr. Aronson's point, or Dr. Plender's point, that it's trying to circumvent. It's autologic para 54, where the court says the crucial, which I just happen to have open in front of me, the crucial point which emerged from Mr. Aronson's argument, however, and was at no point, as it seemed to me, effectively answered by Dr. Plender for the revenue, is that these claims are made at common law and not with a view to obtaining any statutory remedy. That's a procedural answer.
I understand that. But putting it at its simplest, the Section 80 claim that you lost in BTCA was, we have overpaid VAT, hence we have a right under Section 80, and because we got our letter in before the Fleming claim window closed, that claim was in time. The answer that the Court of Appeal gave to it was, there was no Section 80 claim. Incidentally, we don't think your letter was a reference to Section 80, but leave that on one side. There was no Section 80 claim because there was no overpayment. So it's been decided as an issue in those proceedings, as I understand it, that the VAT paid at T3, to use Ms. Mitrofanus's chronology, was due. Now, in this claim, you seek to say we overpaid by mistake. That is the fundamental basis of your restitutionary claim. It's necessarily implicit in that you overpaid. Ms. Mitrofanus says you can't run that point because it's already been decided you didn't overpay. And at the moment, I'm struggling to see why you say there's nothing inconsistent in those two positions. And I understand that this is a common law claim, not a statutory claim. I understand this is a common law claim, not an EU law claim. But it depends at its heart, I thought, on the proposition you've overpaid. You've paid too much VAT, and it's that which seems, or which is said by Ms. Mitrofanus, for reasons that I understand, to be inconsistent with the conclusion reached in BTCA.
I'm grateful for the question because it goes to the heart of so much. The answer is, one has to remind oneself, Section 80 is a delivery system. It is an attempt by the UK to deliver through a statutory mechanism on its St. Giorgio obligations. It does not decide liability. You bring your liability to Section 80 and the gatekeeper decides, is it covered or is it not? So that's point one. point 2, you will have in mind para 54 of, I think, which I just read out, where Lord Justice says the actual delivery system, albeit he's talking about the earlier period, the actual vehicle that a taxpayer uses to recover its claim may be neither here nor there. I put it slightly higher than he put it. So point 1, it's a delivery system. Point 2, there is certain fluidity and flexibility as to how the taxpayer, or what delivery system the taxpayer can use. But that's all domestic law. And that's the critical thing. It's my third point. Section 80 was construed in para 125 of BT as a piece of domestic law, to be blunt, which completely missed the target. By that I mean, you've seen Article 11C1. I made the point the other day that will come into its own where the VAT has been paid and then the rebate, bad debt, the cancellation occurs. 125 is not bad debt specific. 125 of BTCA says this provision does not work if you have lawfully paid the VAT in the first place. That's what it says.
Sorry, 125
of BTCA.
Yeah.
And it was on that narrow point that we lost.
Sorry, you said it's not specific to what?
It's not. It's not specific to bad debts. That's what was on the table. But it's worth opening it. Para 125 is at page 1130. I say 125.
It's 125 to 128.
Exactly. And it's between letters F and G, which is reasoning that would apply to all of the gateways in 11C1. So it's just at letter F. The subsequent failure of the customer to pay for the supply gave rise to a bad debt and a possible claim for bad debt relief, which would be for the repayment of all or part of the output tax originally paid by BT. The arising of such bad debt did not, however, mean that the output tax earlier paid was not output tax due within the meaning of Section 80. It was and remains so, and the arising of the bad debt did not retrospectively change that. And that's a reference. Section 80 isn't set out in this judgment. Section 24 is. Just finding it. 29. I'm very grateful. 29. So at page 1100. And the Crown's point, Dr. Lattock's point, is a very simple one, and it found favour. Where a person, I'm looking at 24.1, where a person has paid an amount to the commissioners by way of VAT which was not tax due to them, they shall be liable to repay the amount to him. And his point, see para 30, was, but it was due when you paid it, and that's what the court accepted at 125 to 128. And that is a piece of logic that would apply to all Article 11C claims, other than group which may not even exist, which I mentioned yesterday, which is people who discover that there's a bad debt even before they put their VAT return in. So it's a very simple, somewhat nuclear point, and it means we in this country, our putative go-to mechanism doesn't cover cases where, or certainly the version that I'm showing you on page 1100, the section 24 version, would never cover a situation where the tax was lawfully paid and then an 11C1 event, certainly a bad debt event, occurred. At this point, say, well, that's unfortunate, but it doesn't mean that we didn't acquire at European law level our Article 11C rights, and we then, Lord Justice Newey lifts the bonnet on that whole machinery, albeit he's looking at it for a different gateway in Iveco. But indeed, it would appear, even from 125 to 128 of BTCA, that the court wasn't denying that there was an underlying claim. We simply didn't go into it or the court didn't go into it in BTCA. They simply said, you don't fall within the words of 24.1. And those words were later changed, and this was argued, what I'm about to say was argued in BTCA, but it didn't feature in the judgment. Those words, we go back to Iveco, one sees at page 1443 the version, and these versions have retrospective effect, of Section 80. So where Section 80 got to, and I think it got to this point by 2005, letter D, it's paragraph 13. So we're back in Iveco. So the updated version, which, as I say, isn't quoted in BTCA, has this format: Section 80, 1b, little b, in so doing, has brought into account as output tax an amount that was not output tax due. Now that is slightly broader and is capable, we said in BTCA, of covering someone who, during who goes on failing to exercise their set-off rights in ignorance after the 11C event, bad debt, rebate, whatever, has occurred. And that was one barrel. The other barrel was 81 big B, which is a very intricately worded provision. These are both what Lord Justice Newey was talking about in one of the passages that I just read, where a person has prescribed accounting period and rendered paid to the commissioners an amount by way of that was not that due to them, otherwise, as a result of A, an amount that was not output tax due being brought into account as output tax, end of quote. So double negative, but we say that certainly captures our situation where we paid something that was due at one level, but in an overall sense, it exceeded the taxpayer's net liability. So
you've distinguished between being due as a matter of domestic law and being due as a matter of EU law.
I have.
Does that mean you read Section 81B as if the word due in the third line, that was not VAT due to them, means as a matter of EU law?
Yes.
But in little a, an amount that was not output tax due, you read that as mean as a matter of domestic law?
No, I would submit that one reads both of them in a manner which is consistent with EU law, because 11C, 11.1C, 11C1 is operating at all times. But I remind myself that Lord Justice Newey said it doesn't really matter, and what Lord Justice Newey is looking at, where he says that, forgive me, let's get back to that passage, he's looking at these follow-on overpayments, it is, thank you so much. So paragraph 54, page 1457, last few lines, viewing matters where I do the words were apt to apply, section 05, section 8 was amended, but one or other of sections 1 and 1b, I don't think it's necessary to decide which will then have been applicable. So this is the discussion of these further overpayments, which my learned friend successfully argued for as an analysis. So my big point. Excuse me 1 second. So whatever the construction of Section 80 as a piece of domestic legislation, we lost that argument. The current argument is obviously about bad debt relief. And in a sense, Section 80 is no more than a cue ball in terms of my presentation. It provoked Lord Justice Nugee. It was part of, rather. Lord Justice Nugee is what I described as lifting the bonnet and explaining how it all works. And it enables me to say that there is another reality, the EU law, Article 11C1 operation. And if we need to have an accrued right, which we don't, there it is. That really, I've taken a long time over this, I do apologize. But that's how it fits in.
Okay, thank you.
I leave that topic now, and I've got a series of short points, all of which have been trailed, I think, in writing. First of all, and quite closely connected to what we've just been looking at, is our machinery point. That's C5, it's in our skeleton at paragraph 28, page 18. And essentially it's our response to the Commissioner seeking to rely on the statutory obligation to pay in advance, perfectly proper obligation, Article 10 of the Sixth Directive. And we say that is machinery. We've moved definitively, obviously, from the world of Section 80, what does it mean, what does it not mean, to the world of common law restitution. And you would have noted 2 days ago that Article 10 is headed taxable event, whereas Articles 11A and C deal with taxable amount. And that is significant. May I briefly show you the XL case, decision of Mrs. Justice Cockrell. It's in Divider 63, 1908.
While we're getting that, do you accept, I don't think there's any dispute on this, that Article 10 sets up as the default time for payment, the time of performance?
Yes.
Yes,
Absolutely.
although there's a little qualification on that where the services are provided over a period, which would apply to phone bills, but it's at the end of the period.
Exactly.
Yes. So it's not that there's a default taxable event when payment is made by the customer. It's when you make the supply.
Precisely. And then there's
Yes.
a derogation,
Yes.
obviously for reasons of cash flow and so forth, and point of view of the state. The XL case, it is the facts are rather unusual. It's the aftermath of an alleged fraud. The fraudster at least paid his supposed tax bills by declaring the alleged proceeds as income, and in the restitutionary litigation that followed, HMRC was sought to be drawn in on the basis that they've had some of the money, and they weren't drawn in. This is only about their presence. The commissioners, I refer the court to 34 and 35 at page 1914. 34 and 35. My learned junior, Mr. Rattan, appeared for the Crown on that occasion. And he argued that the money was due when paid, and therefore there's no space for restitutionary remedy. The reaction at 34 was, on this point, it seems to me that HMRC's arguments have something of a smoke and mirrors character. HMRC looks to section 2059B and says that this creates a real obligation, as real and enforceable as any other. I consider that it is well arguable that this isn't the case, bearing in mind the statutory structure as applied to the rather unusual facts of this case. In particular, I accept the submission that while the relevant provisions do create a statutory debt, section 59B does not itself create a liability, but rather deals with the mechanism by which tax becomes payable. She refers to Lord Dunedin. I won't read the quote, but his lordship refers to the classic three-stage process of levying taxation. And then at 37, she says this: that point has more recently been made by Lord Carnwath in Derry, albeit in a case where the focus was on a different part of the TMA. Quote, the TMA, as its title implies, is concerned principally with the management of the tax rather than fixing liability. The fact that Whitney was a very different case in the present, there being a submission that there was no liability tax because of territorial limitations on its own machinery, is neither here nor there. What Lord Dunedin does, and Lord Carnwath does also, is to draw a distinction between the liability to tax and the mechanics of calculating the charge. That distinction is important here.
Just to pause there, Mr. Cordara, I'm not aware of Whitney having been explicitly applied in the VAT case. It's very much a direct tax case. I assume you're relying on it by analogy.
By analogy, just at a logical level.
Yes.
I think that's probably, I'd also, yes, I've finished the citation and then perhaps I'll just add one short point. At 40, she says, her ladyship says, however, these considerations generally proceed on the assumption that self-assessment sits on top of a genuine liability. It must be very rare, if not vanishingly so, for a person to declare in their self-assessment a liability which doesn't in reality exist. At 42, of course it makes perfect sense that there should be a tightly defined scheme as between the taxpayer and the authorities. But that scheme is predicated on the existence of a liability. The paradigm involves the existence of a liability which has to be determined and enforced. As Mr. Rattan put it, self-assessment provisions answer the question as to the amount of a liability owed. It would not, it seems to me, naturally come within the contemplation of the drafters that a taxpayer might, for nefarious purposes, declare a liability where there was none. Here, therefore, we are operating outside the paradigm upon which the self-assessment structure is predicated. 43. It must, in my judgment, be at least arguable that there can be no taxation, or that the prima facie liability taxation can be unpicked where there is no liability to tax. And I won't read on. We're obviously dealing with refunds and a different tax, but in terms of tax design, I would submit, mindful of my lady's comment, that there's a universality here. There is, indeed, our case is slightly stronger because this case I'm citing, dealt with calculation of the liability, and her ladyship was willing to accept the arguability of a proposition that sits apart from the true ascertainment of the underlying liability. In our case, Article 10 doesn't deal with the calculation of the liability. That's always done by Articles 11A and C. The function of Article 10 is simply when. It takes no position on amount whatsoever. So in this case, we've got an evaluative question. Okay, the case before this court common law case, as to whether or not presence or indeed the comments made by BTCA, for example, just to jump back very briefly to that discussion. There, we're looking at a delivery system which is neutral. It will hoover up what it can, but it can't be put any higher than that in terms of impacting on the unfolding Article 11C story, C or justice. That's that case. I'm just going to zip through now, if I may. Our causation point at C4, paragraph second skeleton, paragraph 7.1 and 24 to 27. That's the DMG point. You've heard more than enough from us on that point, and I will say no more about it. Then at C6, para 30, there is the forbearance point. That brings us into GIB territory. My learned friend very properly said yesterday, wasn't suggesting that GIB was wrong. And without opening GIB, my learned friend focused on the fact that there was a contract in the story, the GIB story, termination contract, and there is no contract in this case. Obviously, this is a case where the exercise which concerns the relationship between the state and a trader, that is not a creature of contract. But it's also right to say that in GIB, the contract ultimately was held to be void, and therefore the role of contract as potentially in some way putting GIB in a different place, analytically for the purposes of the common law claim in terms of mistake, is non-existent. But the key point is that the approach is accepted.
Well, I think what she accepted, to be fair to her, was that where a person gives up a right, that can be treated as a transfer of value. And she says it's different if you simply don't exercise a right. You're not giving anything up, you've just let time go. That was the distinction I understood her to draw.
I've not done my learned friend justice there. But it comes to the same thing in that the economic value in contention remains with the party against whom the allegation of unjust enrichment is made. It doesn't move to the party making the claim. Whether the claim has been given up or simply not exercised, that impacts on whether or not there has been an operative mistake, because if it has not merely been not exercised but is there still to be exercised, then there hasn't been an operative mistake, and that's ground we covered on day one. But the very simple point that something has to move is not right. If it is to be said, something has to move when all the other elements of the mistake claim have already coalesced. That's back to saying, well, the money was due when paid. And this is what I meant when I said there's a sort of photographic freeze frame approach in the commissioner's approach, rather than letting the camera run. So the money goes to one location, that's T1, in circumstances where it's unexceptionable. Events then occur, and depending on the story, it never comes back. One doesn't have to have injustice at the moment that the original movement of value takes place. That can follow. That's DMG.
When do you say the value moved, at T2 or at T3?
Well, the original payment was at T1,
Yes, but you've accepted that.
Yes.
Well, let me be clear.
Yes.
At T1, there's a payment, so there's a transfer of value,
Yes.
but that wasn't unjust because
Exactly.
there was no mistake at that stage.
Indeed.
T2, the debt turns bad 6 months later. T3, you make a payment for a VAT period in which you could, had you known about it, have included your T2 claim, but you don't.
Indeed.
So you pay more than you would have done had you made a claim. When do you say?
T3 definitely.
Yes.
It's dependent, T3 is dependent on your being a busy trader and having output tax, fresh output tax, against which you could have but did not set the historic.
Yeah.
That's probably a fair assumption for BT.
I think it just about is. You might be not very busy.
Yeah.
In which case, there is never a T3. There is simply an unexercised right at T2, which you then lose the passing of time.
Do you say that would be enough?
I do, because that's DMG. Because the DMG obviously is structured completely differently. It's not a turnover tax. It's only ever T2. I say that with some hesitation. There may be some settings that I don't know about.
No, no.
Sorry,
but
so are you alighting on T3 for BT or actually T2?
I probably should not have gone there. T3 is BT. I should keep it simple. But there won't always be a set-off, put it that way. And you'd be entitled, when you make sense of all of this, to note that there won't always be a T3. There is a T3 with us.
What I've written down is in BT's case, you definitely had overpaid by T3. You might, in another case, if you weren't a payment trader, regularly returning VAT returns, you might have an argument that it was T2, but you don't need to run that argument.
I do not. I've run enough arguments with that.
Yes.
Then, just to move through the remaining points, prudential. Again, I'm going to ask you to open it. It's Divider 56, page 1481. We deal with, or the commissioners raised this in their respondent's notice at para 13. My learned friend made submissions. The response is, one, there was nothing novel in terms of principle for the purposes of restitution that came out of that case. Two, however, there was a rigorous application of those principles to the suggestion that when your T1 moment you actually pay, two things happen. You hand over the money and the opportunity to use the money. And that then led to a compound interest decision. And the court simply says no. This is a para 69 to 71, page 1517. It's just money being handed over. There's no shadow economic situation. And we are a classic one-track case. No one is suggesting anything other than the handing over and then the set-off story. So that's our short answer to prudential. Similar structure to my answer to ITC. That's Divider 52, page 1369. That was tripartite, as you may remember. And lead claimant investors were charged VAT by an investment entity wrongly. It had paid VAT wrongly onwards to the commissioners. And again, classic restitution law, forced age test applied, so nothing to see there in terms of principle that was other than that which parties I think are pretty much agreed on anyway. There, however, the issue was, could the lead claimant, which was the final consumer look through the investment company to claim from the commissioner's restitution of VAT that they had overpaid, and the factual answer given by the court was, well, there's no transfer of value from the final consumer through his supplier, its supplier, to HMRC. You have to look at each stage, and there was bandied about loose language such as in VAT, the trader is the tax collector for the government, and so on. The court said, just look at the facts. It's a compartmentalized story, and it has to stay binary. So there's that point. Then there is the point that I want to add in response to these various endeavours by the commissioners to undermine the concept of what is a transfer. Just a simple point, total failure of consideration in a contract case. So I buy my ticket, I get on the ship, it sinks, classic Australian case to that effect, and held total failure of consideration. But it's referable back to a moment when the contract was alive and well, and it's a classic case where the supervening event comes later. There's no further payment. And if the Crown were right, it would be very hard to see how those cases are correct in principle. It's a very short and simple answer.
But you couldn't bring a mistake claim by getting on a ship which later sinks.
True. Well,
No, I mean, in real terms, you might well say it was a mistake, but it wasn't a mistake when you bought the ticket.
correct. But but I'm thinking of total failure consideration cases as a branch. I've strayed off into contract law now. As a branch.
I understand that. It's a transfer of value.
There's no mistake.
Where it's normatively defective, to use that slightly difficult phrase. But what is defective in a total failure of consideration is that it's a contract, which is a perfectly valid contract when entered into, under which you pay money for something in return, and you never get the thing in return. Now, that's a very different situation from paying money by mistake, is it not?
It is indeed. It is indeed. And it was the more basic point that you've got a transfer, it was properly made, the basis then failed to use
Yes,
the
yes,
jargon.
yes. And the same is true of frustration, and the same is true
Absolutely.
of misrepresentation leading to a rescission and so on. There are all sorts of ways in which contracts can come apart and monies paid can be recovered. Some of them are because there was never a contract in the first place, the swaps cases. But many of them are perfectly good contracts in the first place, but they turn out not to work. But those do seem to me to be a different type of defective transfer of value than I paid you money under a mistake.
Well, if I can rewind the story to position ourselves within 6 years and therefore in Woolwich territory,
Yes.
that would be an analogy. There's no mistake to complicate matters. In one sense, we're climbing around. Council is climbing around inside the machine of restitution at this point. What's a transfer and what isn't a transfer?
Yes.
And what I would submit, and I have done too often, is Article 10 is like buying the ticket. It's perfectly fine, and then something happens.
So your point is
Failure of
the
basis.
transfer of value that took place at T1 was perfectly good at T1. It is retrospectively invalidated because it was only a provisional payment. If you want to know what was actually due, you have to look at Article 11A and C, and once you apply Article 11C, it turns out that the £100 you paid at T1 was £10 too much. That's right?
That's it.
And you say that's analogous to buying a ticket when the ship later sinking.
Yes. If it matters.
If it matters.
Then moving forward, come to cross appeal. And
This is issue 3.
yes. At this point, I defend his lordship. I put it that way. Again, I can take these, I think, fairly simply. His lordship was persuaded that there is a viable, really what I've just been talking about. His lordship was persuaded that there was a viable case for the overpayment of taxes. See his judgment at 112 to 114, 117 and 119. He thought our DMG argument had legs. We have been through that sufficiently, and I don't think there's anything I need to add there, so I apologise, slightly wasted your time there. At 118, his lordship noted our submissions on Iveco. He understood that our major reliance on Iveco at 118 was for the automatic operation of the 11C. Had my suspicions on that far too great a length, so I got nothing to add there. And moving forward, 115, paragraph 115, the judgment. He notes the Goff and Jones passages. Again, I don't think they've been subject to submissions. We say he was entitled to do that. 116, the essential mistake. 117, as I've already said, the Deutsche. So those are my responses in defence of his lordship's decision there. That brings me to the 9-month point, which is dealt with in the respondent's notice at 16 to 24. And as we've seen, so responses as follows. Number one, as we have seen, the absence of the old scheme in the first 9 months has the impact that there was not the requirement to have made a claim. 2, factually, we say that one doesn't just look at those 9 months in isolation. This is a simple evidential point that I make. It's clear that the subsequent enactment of the old scheme would have coloured the understanding of BT staff, assuming they even knew about the non-implementation back in 1978. I don't know how often they went down in Holborn in those days to the stationery office, as it was then, where one bought paper. But assuming that they did, or irrespective of whether they knew the non-implementation, they would have then seen the words of Section 12, and therefore the inquiry that would be made, were this to be permitted to go to trial, would be the same both for the 9-month period and the main period. You have my submissions on all of that. We have said in our skeleton argument at paragraphs 43.1 and 51.2 that the 2 periods must be seen together, that the causative impact of the misleadingly worded legislation would have related back to the 9-month period. It's all very obvious.
Well, sorry, you can.
No, please.
You've talked about whether BT staff would go and look this up and so on, and it being a matter of evidence. but if you look at the way it's dealt with in FII, with, for example, a reference to expert evidence and a reference to the position of multinational groups,
Yes.
and bearing in mind there's an objective test as well as an objective test as an alternative to a subjective test in 32(1)(c. Do you say it's a matter for evidence as to whether, for example, it would have been appropriate to get some VAT specialist advice?
I say it's my lady's question is a matter upon which we have actually, to which we have given quite a lot of anxious thought, because you need, well, first of all, you do need, I'm thinking of the evidence in DMG of Mr. Thomason. I don't know if you had occasion to see the quotes in DMG, but he was asked and he said basically, look, I read the law, I presumed that was the law, and that was short end.
Okay, but we now have FII, and which has got quite a lot of guidance in it.
It's got a great deal.
Which might be read as indicating you don't stop with Mr. Thomason.
No, I can quite see that, and the anxiety, if I can reveal some of the workings behind the scenes, the anxiety is that you may need an expert to say what the experts knew at the time.
To what extent does the court need an expert when, for example, HMRC is relying on the Goldsmiths case being there, and it was reported in Simon's tax cases in 1997?
One that's miles away from this case.
No, we're talking about the 9-month period at the moment.
Fair enough.
Can we focus on the 9-month period?
Well, first of all, the Supreme Court has said that this is a question of fact.
Right.
So if you allow it to go forward, we'll find some kind of a solution, and it may well be one I can't imagine at the moment. That's point one. At point two, I would submit that the Mr. Thomason equivalent will have a role in the story, because he or she would be the person to decide whether to go to management and say, something here. Thirdly, and I'm not giving evidence about this case, but the court may know that the way this market has operated, albeit probably from a slightly later or considerably later date than 1978, is that the accounting firms tend to be the source of guidance to the industry, rather than, say, lawyers. One doesn't necessarily have any lawyers in tax departments. So there's a whole argument as to what should be the level of expertise, and my lady may be thinking of passages in which these matters are discussed.
Indeed, they are.
Indeed. But given my own experience of giving inaccurate advice over the years to clients, because I couldn't possibly imagine that X or Y would, I think in particular of the development of the abuse doctrine, for example.
Yes.
Which is very well established.
Yes. As I say, my questions are very much focused on the 9-month period.
Yes. So let's come back to that. So what you needed to know was that there was such a thing as directly affected rights, and that they had exploded in terms of the move from the Second Directive to the Sixth Directive. And my learned friend mentioned gratin to the court yesterday, very properly, and that's an example, absolutely in our sphere, of a completely new step. Oh, what? We can actually look at the past and have some money back. That was brand new. And
Brand new when? Sorry.
with the Sixth Directive,
Yes.
which came in 77, effective 1 January 78. So even the concept was new, and it would be, were we to get to trial, I mean, one of the things I would advise my clients to do is actually get the publication dates. I'm thinking 9 months. When did the official journal come out? When did it reach London? When could you know?
But you've got to pass all these tests up to 2004
Yes, indeed.
to succeed.
Yes, but let's go back to the 9 months. We have a very knowledgeable and well-resourced yardstick in all of this, which is HMRC, who fought until 2014 on the basis that this was covered. This was within the acceptable discretion. But that's not on the table, I accept, in the 9-month period. But the other side of the coin, in this case, is HMRC have got to say it was unreasonable for us not to know, while themselves not knowing. No question of HMRC behaving badly. I'm presuming that at all times they genuinely thought we were wrong.
Can I raise another question, going back to my Lord's questions at the opening of today about the
Yes.
procedures? We've now got the application notice and the accompanying grounds. Well, we've got them anyway. Well, let me just tell you
Yes,
the
tell me.
point. The point is this, that under the heading claim for damages for breach of EU law is time barred, the grounds say that BT have identified reliance on section 32(1)(c), the response to which is section 32(1)(c) has no application to a claim for damages for breach of EU law. It only applies where mistake is an element of the cause of action. It's not an element in any claim for damages for breach of EU law. So the grounds don't seem to have made the point that the judge thought should go to trial. Didn't seem to have been raised as responses. In other words, it wasn't saying you can't possibly make out
Yes.
ignorance or reasonable ignorance. So I'm just wondering how this actually developed in practice. You may not be able to answer that.
I'm not able to answer. Yes.
So if I've understood, the position was that the claim started off with a much wider scope. There was a claim for damages for breach of EU law.
Yeah.
There was a claim for compound interest, and there was a claim for the pre-1978 period.
Yeah.
I think soon after we put in our strikeout application, those were step by step withdrawn. So by the time we got to the hearing before Mr. Justice Miles, it was simply issues 1, 2, and 3.
Yes,
Does that answer the point,
but
or
not
am I
quite, because
misunderstood?
my point was that all that was being said about why section 32(1)(c) didn't apply in the grounds was the points that I've just read out.
Yeah, in other words, it's only raised under the damages.
It was only raised in that context. As far as I can see, I've only read this very quickly.
I think it's raised
I'll
at
come back to that in
paragraph.
the reply then.
Yes.
I think it's raised at paragraph 16 as well,
Oh, is
under,
it?
under the claim for the 9-month period. To the extent that BT seeks to rely on section 32(1)(c) for this 9-month period, with reasonable diligence, the Article 11(c)(1) right, its non-implementation,
Oh, I
and
see.
the enforcement of that right would have been discoverable from the 1st of January.
Sorry, that was a bad point made by me, which I'll then probably withdraw.
Sorry, I'm grateful.
Thank you. Thank you to my Lord.
I'm not blessed with any of these
No,
documents.
you've been telling us, Mr. Cordara, how difficult it would have been for BT to discover the true position.
Yes, I was just beginning.
You were just beginning to do that.
Yes.
Can I take you a step back and ask for your formulation of what mistake BT made in relation to the 9-month period? Because when I asked you this question 2 days ago, you said the mistake was thinking that the UK had correctly implemented Article 11(c)(1) in the regulations, which obviously doesn't apply to a 9-month period.
That wasn't a good answer.
Well, it may or may not be. It was the answer you gave, but it doesn't apply to a 9-month, except on the footing that once enacted, the old scheme sweeps up a 9-month period, which is an argument that HMRC have, but it's not one that's being put before us.
There's a middle argument, which is this, that you realise that you missed out on something in the 9-month period, and you then look at what then arrives in terms of the old scheme, and you see what you see, which doesn't apply to BT ex facie. And the mistake is thinking that must be what you missed out on. That is a snapshot of the rights that were not implemented, and is the measure, therefore, of your European law, the basis upon which you might have made a European law challenge. And the member state says, sorry we're late, this was the first reel of the film, as it were, which you can see, and this is the measure of what you missed out on. So there's no point, because it doesn't apply to you anyway. So it's just a retrospect. I've given the answer, so it's slightly discursive. But in other words, you look at what then did arrive, and you presume that's what should have arrived 9 months earlier. You see it doesn't apply to your business, and end of story.
Oh, okay, so you're saying it's effectively infected by the mistake,
Yes.
the later mistake about the insolvency.
Yes, and it's not quite so retrospective, prospective in the sense that it's the making of the claim, obviously, that didn't happen, and that is something that could have happened within the 9 months in theory, but also there were many years thereafter when the retrospective claim could have been made. So it's only if someone saw the old scheme and could conclude that it was defective, that you would then make the next step and say, well, in that case, we've lost out on something in the first 9 months, assuming that the old scheme was a representation of what the UK could lawfully give you, or get away with giving you, had it implemented straight away. So it's a yardstick effect. These are your rights under European law, mediated by our discretion in any condition.
I think I understand that. And then you were in the middle of telling us why it was not reasonably discoverable.
Yes.
And I think, is this right, that the onus is on you to show when it became reasonably discoverable?
The onus is on us.
Yes.
And-
Or rather,
and-
to show that it was not reasonably discoverable before 2004, 6 years before you
That's right.
issued your claim.
That's right. So first of all, you need. I won't try and identify the reasonable man or woman in the story, because it could be a lawyer, it could be a specialist, it could be the tax managers. There's a whole universe there, which let's not go to today. But the ingredients that you have, there are such things as directly effective rights. And those can be accessed irrespective of what your domestic legislation about the substantive position says, and indeed irrespective of the delivery systems in your legislation, your local legislation, means of access to directly effective rights. So it's a somewhat abstract place to start, but it is a place to start. Secondly, a very simple human point, you don't any longer believe the law on the statute book to be the law. And just anecdotally, I remember in the early days of VAT, it wasn't always easy. The cases were dealt with in the Queen's Bench in those days, to make the point that now it's bread and butter, that the Queen's printer's copy is not necessarily the law. We know that, and we live it, but it was the first time in history that that was true. And they'd been 4 or 5 years beforehand, after accession. But that is a big thing, especially for non-lawyers. And that was Mr. Thomason's evidence. And that tectonic plate has to move, number one, at all. And secondly, it has to move, obviously, with respect to taxable turnover being something that is independent of the words in British statutes, or that you can have a position where British statutes are silent, but nonetheless there is a powerful legal order there in the cracks which you can't see. So that's the second part of the jigsaw. And as my lady puts to me, Goldsmiths comes along, and I believe the date of Goldsmiths was 97.
Yeah.
So we've jumped 20 years before we get the first case. So 20 years of no one making claims of any kind, 20 years of complete acceptance that the commissioners in the legislation got it right. And then, as my lady observed yesterday, it was about a fairly discrete point, barter versus cash. So, so that gets us to the very late 90s. At that point, one has also got Section 80, obviously on the statute book, and there's a bifurcation in this story which is important. We have to know. One doesn't have to know every detail of one's claim. I think that's clear from
You need to know enough to start
exactly. But
embarking on the preliminaries.
yes, embarking on the preliminaries, and there is the Section 80 road, which proved to be a dead end, but was very much the focus, as you know in the story, for those who wanted to give effect or get effect, enjoy the direct effect of the underlying rights. And the taxpayer would need to have known, don't go that way, it will end in disaster.
Well,
it's a dead end.
or could be advised, as BT ultimately was, to back more than one horse.
Indeed, but the reason, I'll tell you why. The court asked yesterday, I mustn't interrupt myself too long, and I've got my own clock.
Yeah.
What changed in 2010? And I will tell you what changed in 2010 in a moment. But one needs to know that that's a dead end, number one. And matters obviously complicated by the 3-year cap. Let me put that on one side. One then needs to understand how Article 11A and C, particularly C, work, and in particular the moving parts in terms of direct effect, conditions, and discretions. And apart from Goldsmiths, I can't remember before the turn of this century, but my learned friend is going to correct me if I'm wrong, cases which began to look at unlawful exercises of discretion by member states within a situation where they're given an express discretion by the margin of appreciation, the level of deference. So you've got to make that transition into not believing what's necessarily on the statute book. You've then got to make the transition into your discretion is reviewable, and we think you've got it wrong. And if Goldsmiths only happens in 97, that period between that and 2004, I'm not sure there were any more milestones. Everybody was engaged anyway in Marks and Spencer's. I can just anecdotally, because it was the 3-year cap. That doesn't really figure. And the short point is, I can't think of any other milestones in that period which would have led to this coalescing. What did lead to this coalescing was a combination of this is more a political fact than an analytical fact, the Fleming window. Suddenly, there were lots of claims.
Yeah, but that's post 2004, isn't it?
Well, that's the point. It's post 2004, and that led to a great surge of activity among the accounting firms, to whom most taxpayers look pretty much exclusively for their legal advice, and the accountants were all over this. But that was only from 2007, when I think Fleming was finally won, and then it had to go to the European Court. Now, that process would have accentuated the existence of directly effective rights. But if I can just give you a demonstration, it's a fairly frank comment. When Marks and Spencer's went, my lady will know this, when Marks and Spencer's went to the European Court of Justice, this court had been persuaded not to ask a question of the court concerning the following topic. This court had been persuaded that once a directly effective right had been transposed into UK statute, the right ceased to be accessible on a European law level to taxpayers. And the court accepted that and declined the taxpayer's invitation to make a reference on that point. It accepted other points.
Can you remember when that was?
I think this is 02-ish, 03. It was the Marks and Spencer. 02 was the ECJ.
Thank you.
If you look at the ECJ decision, this is a remarkable fact. There are two things. First of all, the Commission began infringement proceedings against the UK simply by reason of that Court of Appeal decision. Those came to nothing because of the Marks and Spencer's decision, which tidied it up. But if you look at the Marks and Spencer's decision, you will see, and I've only seen 2 or 3 of these ever, the first 2 or 3 pages is a discourse on the unasked question. The court was clearly quite upset that a member state could, judiciary of a member state could conclude that the direct effect terminates as soon as legislation is put in place. The court's making it quite plain that direct effect remains at full strength always. So the point is, if this court can be persuaded of something like that, it tells you a lot, and this is, if I may say so with great respect, absolutely the apex of learning about law on this topic, as late as 2002. In other words, again, just being frank, if this court could not understand at that stage, or be persuaded, I should say, of something so plainly wrong on direct effect, then it is not surprising that it was only later, in the second half of the first decade of 2007, that things came together. And the answer to the question as to what changed in 2010, but I think that was a slightly different question, which was what made you issue the proceedings? I can't remember.
Well, your case is you hadn't discovered, and it wasn't reasonably discoverable by 2004 that you had a claim, that you'd made a mistake. But you must have reached that conclusion that you had made a mistake by 2010 because you issued proceedings on the basis that you'd made a mistake. So there must have been a point in 2004 and 2010 when you came to the conclusion you'd made a mistake.
Right.
And I think all that was said on behalf of the commissioners was that they had never been told what it was that prompted you to the conclusion that you'd made a mistake.
I see. I thought this was a question of whether or not what prompted us to issue these proceedings but that's not the question. And the answer is advice was received, and I haven't looked at the witness statements, which we shared with the Commissioner some years ago now, but it will have been advice received from an accounting firm. While my lady friend is replying, I will turn around. Miss Frawley may, as you can see, her recollection is impeccable. She may be able to enable me to fill that gap, but it will be the receipt of advice from professional advisors. And as I've said, the dynamic in this industry, at least I think it's still true, is that the accountants think about these things and then they go out to the big corporations and they say, have you thought about this? And then
Would you like to instruct us and give us large amounts of fees because we will recover money for you?
That's what drives the industry. That's simply true. Give me. Yes, absolutely. The reason that this is just a footnote, but the reason we issued proceedings, if I can just ask for a 60-second indulgence, you will see at page 828 of the bundle, at para 87 of the GMAC decision, page 828, para 87, not necessarily to be opened, and that was in 2010, and at that page reference, the tribunal records Dr. Lassock saying, if, as he was contending, there is no statutory route, the answer is to seek their remedy in the civil courts. And a short time thereafter, these proceedings were issued. I'm conscious. I've given only a very fragmentary answer to my lady's question.
That's very
But,
helpful, thank you.
I think the only other, I think I'm there. The only, I've got some very, very small bits and pieces now. The lack of particulars, we say, if you otherwise minded to give permission, but you're not happy with the state of the pleadings, we would respectfully invite you to give us a last chance there. Just turning around for a moment, if I may. I've just been asked, very helpfully, just to make one very last point by reference to para 7 of our skeleton argument, the recent one. It's C2. Forgive me, I just make sure I'm giving the court the right reference. It's just a compendious, but it's very fundamental point. C2, headed, it's the one headed the overview of BT's response. 7.
Sorry, thank you.
Sorry. The linchpin of HMRC's case is that the unjust enrichment is barred because at the time of each enrichment there was a statutory obligation to pay. As will be seen, if HMRC fails to establish this proposition to strike out standards, then its other points under issue 2 have no independent force. And we therefore respond to the linchpin provision, which I've been doing, hopefully. And then we remind the court respectively of the structure of the causation machinery and forbearance points, which I've been endeavouring to touch upon as we've gone through. Yes, exactly. So, due or not, we still have a claim. All roads lead back to Dodge.
Thank you. I had one further question, Mr. Cordero. One of the points made on behalf of the Commissioners is that Mr. Justice Miles made an uncharacteristic slip in paragraph 133 when saying that, recording your submission that a reasonably resourced taxpayer could reasonably have supposed that the UK legislation, including the insolvency condition, complied with European law. And at 134, he says he accepted your submissions. What is pointed out, I think correctly, is that this reasonable discoverability point only relates to a 9-month period. And during a 9-month period, you cannot have thought that the insolvency condition was compatible with EU law because there was no insolvency condition at all. Do I take it that your answers that you gave earlier, that once the regulations come into existence, you read them back as covering the 9-month period as to what could have been done in the 9-month period? Is the answer to that point?
Yes, obviously that's right. I see the slip, as it were, but it is exactly what I said a few minutes ago. Oh, this is what we missed out on. We now see that the best we could have hoped for is something with the insolvency condition.
I'm just teasing that out a little bit, seeing how it works. I mean, the state of mind of the relevant person, the Mr. Thomason equivalent, who I take it to be an employee of BT in BT's internal tax department charged with making VAT returns in accordance with the law, from January to October 1978, is presumably we have to pay the VAT on the invoices, and it never occurs to that person that they might have a directly effective claim under Article 11C1, either because they haven't read Article 11C1 or because they believe that the UK legislation does what it's meant to do or whatever.
Yes.
That has nothing to do with the insolvency condition. It's just it never occurs to them to make a claim for bad debt relief at all.
Correct.
I have not quite understood, it's probably my fault, how, assuming the Mr. Thomason equivalent or his accountants who he goes to advice for do read the bad debt regulations when they come in and sees that you need to wait till someone's insolvent, and presumably with some big commercial clients, BT did prove in the insolvency and so on and so forth.
Right.
But concludes that, oh, that stops us from claiming bad debt relief in relation to retail customers because the debts are always too little and it's not worth it anyway. How does that bleed back into the 9-month period when ex hypothesi there was no bad debt relief at all under UK legislation? I've not quite understood that. I'm sorry to be so slow.
Yeah. Thank you. So forgive me. I see. That's a problem. I'm reminded that it was probably not yet privatised in 1978.
Yes.
It would have been part of the post office. With my learned junior makes the right obvious point, the mindset would therefore be one government department to another. That's not an answer to your question, but it's something that one forgets all too easily. But to answer your question, the focus has to be on the making the claim, because the mistake that unfolds over the years is no claim. if one, I entirely accept what my lord says. In the first 9 months, it's just a blank. There's no misrepresentation from any quarter, and people may, as I said earlier, may not even know about directly. It almost takes us back to just missing the train. And I was using that language on Wednesday.
No, I understand that. I understand your cases. In the first 9 months, it never occurred to anybody that there was such a thing as bad debt relief. And that's why you didn't claim it. Yes. What I've not understood is how the later enactment of the regulations of the insolvency condition, which, if you had read them at all, you would have realised, well, that doesn't help us, but how that affects the 9 month period. I'm having difficulty with that, I'll be frank.
It affects your conduct. I think that's the critical point. It affects the conduct of the tax department people in respect of the 9 month period. You've got to insert the human beings into it. It doesn't have a. I'm reminded that quite often is that apparently one could go back. I'm misspoken. Never mind about that. No, I think one has to insert the human beings into it and say it's because they are, after all, the carriers of the mistake mentally. It's their conduct going forward about that past 9 month period that is affected. But even there, one is adding a level of conscious thought which may not have actually occurred. But if one flips it, and someone said, well, why don't you claim for the 9 months? Answer one is, well, the scheme didn't exist then, the bad debt scheme. And the scheme that was brought in, even if it had been brought in earlier, wouldn't have covered us. So that's a conversation that the team.
I see. Yes, I think I do now understand. Yes.
No, I think that's right. The regulations at the time makes the point to place a time limit on them to make one that matters.
Thank you very much.
Most grateful.
Yes. Having asked you how you pronounced your name on the first day, I've now forgotten whether you're Miss Mitrophanes or Mitrophanes.
Mitrophanes, but I don't know.
That's what I thought, but you have been referred to from time to time as Miss Mitrophanes. Well, it's very good of you not to mind. I would mind in your position. Yes, Miss Mitrophanes.
Before I go into my reply, to go back to the first question asked of my learned friend.
Yes.
Regarding the period start and stop points. Article 1 of the Sixth Directive required member states to implement it from the 1st of January 1978. So
yes.
It could only, 11C1 could only apply to supplies from the 1st of January 1978. Because 11C1 says when, I may be misquoting slightly, but when after a supply is made, there's a reduction, there's a bad debt situation.
Yes, but it's not as if you had two separate VAT regimes, a second directive VAT, and then that came to an end, a sixth directive. There was a single continuous imposition of VAT.
Yes.
From the 1st of January 78, the rules changed. But you say it's not just that Article 11C comes in, it's that Article 11C only applies to supplies made after. But that suggests to me that your understanding of what's covered by the 9 month period may not be the same as BT's understanding, but you've agreed the quantum. That's what I have difficulty with. You must have agreed the quantum for something. What did you understand? The 9 months, the order, Mr. Justice Miles's order, dismisses your application to strike out the 9 month period, so it will go to trial. But what is going to trial, and your understanding?
On my understanding, anything before the 1st of January, any VAT supplies before the 1st of January 1978, covered by the second directive, Grattan establishes that you don't have bad debt relief and
Yes.
so on. You don't have the all-important 11C1 prior to the 1st of January 1978. So the supply would have had to have been after the 1st of January 1978.
I'm not sure that follows really clearly from. I mean, we've obviously not heard argument on this. Just looking at Article 1, it's not standout obvious that it only applies to supplies from. It doesn't expressly put it in that way. It just says you have to enact these provisions.
No, that's right.
By that date.
That's
So
right.
one possible reading may be that it applies to bad debts arising out of that date, because that's the operative change.
Well, the words of I fully accept that Article 1 doesn't, but it says you have to adopt 11C1 by the 1st of January. What does
Correct.
11C1 say? It says when after a supply is made, there is a bad debt, etc. Now, that it can only be using a supply is made to mean under the Sixth Directive time period. But in any event, if perhaps I haven't understood, and this is more important than I realised, but if the point is that my learned friend may be seeking some bad debts under the 9-month period for a time when a supply was made prior to the 1st of January 1978, I don't see how any of my arguments on the strikeout would
change. Yes.
Yes.
So
now
maybe
we
it's
don't
not
have-
important, but it just occurred to
Yes.
us that we didn't really understand what this claim was.
I would have thought that the more important question is, when does the 9-month period end? Because we need to know, for example, if you're with me or against me on one of the issues and not the other, you need to know, where does the 9-month period end? And the Section 12 old scheme makes clear, 12.1, subsection 1, that it supplies made from the beginning of the Section 12 coming in, i.e. October 1978. So that's any supplies prior to the 1st of October 1978 come into issue 3.
I see. Okay, thank you.
Now, there was a debate recorded at paragraph 116 to 117 of BTCA.
Sorry,
As to where-
I'm being difficult. I'm sorry, I'm being difficult.
No, no.
The commencement provision in Section 12 that I've seen talks about insolvencies after 1st of October 1978. What have I missed?
Let me dig it out. So 12, subsection 1, subsection A, where a person has supplied goods or services for consideration in money and has accounted for and paid tax on that supply, and the insolvency condition, then is subject to subsection 2 and to your regulations under subsection 3 below, the first mentioned person shall be entitled on making a claim to the Commission as to a refund.
Yeah, I'm looking
it's-
at the final subsection.
Is that D?
No, subsection 6. Section 12, subsection 6. That's the commencement provision. What am I missing?
Well, on its proper construction, you get rid of anything to do with insolvency, and you're left with 12.1a, when a person has supplied goods, and after...
Well, yes, but another moulding interpretation would be to say when the debt becomes bad after 1st of October 78. So I'm just not sure this is
And there was
black
a
and white.
And there was in any event a debate that the upper tribunal considered what happens to the 9-month claim and how far can it come into the old scheme, where the position that's being put to it was discussed. That's recorded just for ease of reference at 116 to 117 of BTCA, where the Court of Appeal says for the 9-month claim, the upper tribunal had some thoughts. Here
Thank
they
you.
are. And that's why it moves, when it comes to its decision, that is the Court of Appeal's decision of 118, to say, well, it's either caught up in the old scheme in the way the upper
Right.
tribunals explained C116 to 117,
Okay.
and blighted by the same problem, or all you have is your 6-year restitutionary claim.
Yes.
Yes.
So the debate at least is at 116 to 117.
Thank you.
And that's the debate we're sort of trying to avoid, at least on the strikeout, by saying that let's not take the point that it's swept up into the old scheme for the strikeout.
Thank you.
Where are we now?
Yep.
I hope that's helpful in delineating the periods,
Thank
at
you.
least for purposes of this court's judgment.
Yes.
So then can I turn to my reply on issue 2? Can I try and set out, I hope clearly, how my learned friend's position is put and then reply to it? My learned friend's position A, as I'll call it. There was a mistaken overpayment of VAT at T3. That seems to be my learned friend's favourite T. So T3. There was an overpayment of VAT. Now I'm narrating the argument, as it were. At T3, after a bad debt arose, the £10 paid at T1 to HMRC was automatically no longer due to HMRC as a matter of how Article 11C1 works.
Yes.
And the argument continues. So yes, at T3, I owed HMRC £150 on the new supplies made for that period. But HMRC owed me £10, given the automatic set-off under Article 11C1. So in fact,
Sorry, automatic set-off under...
Article 11C1, the argument that 11C1 operates automatically. This is my learned friend's argument.
Yes, I don't like the word set-off in that.
I apologise. The automatic operation of
Operation.
11C1.
Yes. because you're about to use set-off in a different sense. It sets off
Right.
against the 150.
So given the automatic operation of Article 11C1, I only owed HMRC £140.
So I overpaid £10.
Therefore, exactly, when I by mistake, not understanding I only owed £140 under the automatic operation of 11C1, in fact made a transfer to HMRC of £150, I paid HMRC £10. I unjustly enriched HMRC through my mistake by £10, and that's my claim for mistake-based restitution.
And I didn't realise that until after 2004.
That's position A,
Yes.
and I'll outline my answer to position A. The £150 BT paid at T3, all of it, including the £10, was all due to HMRC. That BT didn't make a claim for £10 refund, as it were, did not mean the £10 was not due, because there was no automatic operation of Article 11C1. Because for the main claim period, we're not in an IVCO position at all. So when BT didn't make the claim, therefore, when it, on its account, overpaid at T3, it wasn't an overpayment. It was all due to HMRC. And if I can just read out the paragraph 30 of BTCA, which is common ground.
That's exactly what Dr. Lassock said.
But the reason I wanted to read it out is because of a couple of words that answer a new point my learned friend made in his argument. Just bear with me, this here somewhere.
It's Vol 4,
Yes, I have it.
tab 45.
I'm grateful. So, by way of anticipation of the argument in the cross appeal, Mr. Lassock's responsive submission was that Section 24 and its successors, because my learned friend pursued an argument this morning that, well, Section 24 is what BTCA had in mind. It wasn't the successors, it wasn't Section 80 or the version of Section 80 that Avico had in mind in all this. So that's why I wanted to read it out again. And its successors have nothing to do with claims for bad debt relief. They were and are concerned only with cases in which an overpayment of tax has been made to the commissioners and provide a restitutionary basis for the recovery of the excess. In a bad debt case, there was no payment of VAT that was not due, or therefore any overpayment of VAT. A failure to make a bad debt relief claim in a subsequent return, T3, still did not mean that there was any overpayment in the tax actually paid. If no relief claim was made, the tax paid was the tax due. And I won't repeat it, but to the extent that my learned friend wanted to argue and did argue that BTCA wasn't thinking about all the Section 80 versions, or BTCA wasn't thinking about T3, it was thinking about T1, or BTCA can't be final because along came Iveco and said something different. All those arguments have been run, and if the court is interested in seeing them in great detail, the court can look at the first tier tribunal strikeout, the recent one, that is in 2020, which runs to over 100 pages and sets out very clearly every single argument my learned friend wanted to run and responds to it. Or if the court would like the shorter version, I took the court to BT Upper Tribunal 2023, where the automatic magic of 11C1, the automatic operation, the BTCA weren't thinking of Section 80, subsection 1, capital B, they were thinking of something else. All these arguments were run, and it's been finally determined, I emphasize finally determined, in res judicata, that these arguments cannot be run. My learned friend, as the court pointed out this morning, cannot get home on an unjust enrichment case on the basis of position A, I overpaid VAT, given the decisions already made against BT. DMG can't help my learned friend because, rightly or wrongly, in DMG it was considered that DMG had paid tax not due when paid. There had been an unlawful exaction of tax, unlawful in being premature, but it was contrary to EU law.
When you said rightly or wrongly considered, did you mean conceded or conceded and considered?
Both. It was conceded that there was a restitutionary claim, and the court considered that there had been an unlawful exaction of tax contrary to EU law.
Well, but that wasn't an issue by
Gesellschaft.
that stage, because that's what Metal Gesellschaft decided. Isn't that
It was
right?
just, sorry, could you repeat the question?
Metal Gesellschaft decided that the regime for ACT was unlawful.
Yes.
And so when you got to DMG, is this right? The only issue was the limitation issue.
Yes, the only issue was whether it was also a mistake and therefore could benefit from 32(1)(c). But just for clarity, the House of Lords records, and we've got it in our skeleton, that DMG involved the unlawful exaction of tax, contrary to EU law. And the important point is that it's not our case, because what we have in BTCA is a clear and final res judicata decision that no tax paid that was not due. No tax was charged that was not due, no unlawful levying of tax, charging of tax, however one wants to put these Section 80 type terms, they all come down to HMRC is holding money from the trader that is not due to HMRC. And that argument has failed. definitively and repeated in GMAC Court of Appeal also, but of course it's a matter of, in other words, BT has 2 Court of Appeal decisions against it, but one of them is res judicata.
Yes.
And my learned friend at points seemed to be saying, well, BTCA is a sort of domestic case, whereas Avico is a European case. That's simply wrong. In both, when considering Section 80, my learned friend's own arguments were based on EU law. I've got these 11C1 rights. Given my 11C1 rights, I've overpaid tax. Rejected. So that's my answer to position A. If we could just switch now, this is my learned friend's position B, an alternative way of putting his case. Presumably to get around the problem with position A that I've just outlined. And the narration of this argument is something like this. Okay, the £150 I paid at T3 to HMRC, I have to accept all of it was due to HMRC because of BTCA. And I accept that I didn't, by paying £10 out of the £150, overpay HMRC. I lose under my position A. But, and this is position B, by failing to set off, my very failure, my refraining from asking in effect for that £10 relief, my not making a £10 claim from you, HMRC, I unjustly enriched you. It's a forbearance, and that means I spared you paying £10 to me. So it's not, this is a switch of position. I accept I didn't pay you £10, overpay you £10, I lose position A. But I spared you paying me £10, sort of negative unjust enrichment under the Gibb case.
Yep.
And the argument goes that BT, like Miss Gibb, has a case of unjust enrichment. The difficulty with that is that Miss Gibb said, I agreed with the NHS Trust. I wouldn't pursue my claim, and they're unjustly enriched by some amount representing the value of that claim to me. And I agreed to do that on the basis that I'd get £175,000. But you, the NHS Trust, no longer want to pay me because you now say that was all ultra vires position. And Gibb can't help my learned friend because the problem with Gibb is that BT didn't forbear. It didn't agree with HMRC. I won't ask for the £10 from you if you pay me £175,000. It just didn't make the claim. That it was mistaken in not making the claim doesn't help. Fundamental problem is there's no unjust enrichment. HMRC wasn't enriched at BT's expense when BT failed to make the claim at T3 or at T4.
Well, in economic terms, HMRC is better off if BT doesn't make the claim. And that was what Mr. Cordero said. But your answer is it needs a normatively defective transfer of value. And there's no transfer of value when you don't make a claim. It's just you haven't made a claim.
I don't have them to hand, but the ITC paragraphs I went to setting out what it is to benefit at somebody else's, for a defendant to be enriched at the claimant's expense, makes clear that it's not the sort of thing my learned friend's been arguing. It's not enough to say, well, in economic terms, of course, somebody's better off when a claim hasn't been made against them. That's not sufficient. It's not a economic reality, I am now richer.
Yes.
And as I say, the only case I'm aware of, and evidently my learned friend also, of this negative type of enrichment where it's not that I overpaid you, but I spared you by not claiming, is Gibb. And it was an agreement forbearance case. It's not this case at all. And presumably that's why there was no pleaded forbearance type case my learned friend made.
Mr. Mitrofanous, I've noticed for time. How much longer? How much longer do you want?
I think that's all I had on issue 2, and I was going to deal with issue 3 briefly. So if 5 minutes. I apologise for
Yes.
starting over that, but it's something a lot in that
Yes.
ballpark.
Yes. Let's continue.
So, on the issue 2, that's our position. Nothing that my learned friend can say by going back to the High Court, no factual evidence that it can rely on, is going to be able to convince the High Court that my learned friend can get home on issue 2, under position A or under position B, hence the strikeout. So, unless there's questions on issue 2, I was going to move on to issue 3. Now, in relation to the 9-month claim, if it's put as a position B type situation, which is what it seems to be sometimes, I won't, then the Gibb point arises again. So if the idea is that you had some directly effective rights at T3, and you somehow didn't bring that claim against HMRC, then it's a failure to claim. And our point is that, going back to what BTCA said, although didn't have to decide, in the 9-month period, before the old scheme comes along, what you have is a 6-year restitutionary claim, 6-year limited restitutionary claim.
That's what?
Because
A San Giorgio claim, given effect to in domestic law?
it'll be something presumably...
I understand, you've just mentioned position B, but I understood you to be saying, for present purposes at least, that in relation to the 9-month period, you wouldn't effectively contest position A. In other words, you would accept that at some point there is an overpayment.
Can I take it in steps?
Okay.
Because of these
Yes.
multiple positions. So, in our skeleton argument, just so that I don't accidentally say that go beyond what I'm saying, our primary position on the 9-month claim is yes, paragraph 50. BT's position is that T1 payment becomes an overpayment when a bad debt arises, a sort of failure of consideration type argument.
Yeah.
And that's not a mistake-based argument. That's an ordinary restitutionary argument with a 6-year limitation period. That's what BTCA said in paragraph 118 of BTCA. BT's claimed mistake in failing to realise that it had such a claim is just a mistaken failure to claim type argument, which for the reasons I've given is unsound. there's no unjust enrichment for mistake simply because you failed to bring a claim in time. And then, sorry, I thought there was a question.
Carry on.
And then, my learned friend, and I'm not sure quite how he puts it, because I wasn't sure at which period he was necessarily in when he was making it, but I'll give my answer and then we can see. My learned friend would say, and about the 9-month period, that it's IVECO territory. And I think my lady, a point was put to him on that basis when he was going through IVECO. So that's looking at the 9-month period. That would be the potential overlap, wouldn't it? Because if you're not relying on your old scheme applying to the 9-month period, then I think my learned friends called it a state of nature. Just as in IVECO, there was no implementing provision. In the 9-month period, there's no implementing provision. And so potentially here, my learned friend might say, oh yes, in the 9-month period, there was this automatic reduction operation of 11C1. And the problem there is that in IVECO, it was decided that it was a Section 80 claim. That's what Mr. Justice Miles refers to as the sting in the IVECO tail. And in the blue bundle, there's just one page I want to go to in the transcript from the Upper Tribunal hearing, the recent one in 2023. It should be the last tab in my blue bundle. If the court could go through to day 1, page 65, internal page 65, it's 4 pages to a sheet. So if we go to line 23, just to explain what was happening at this stage, my learned friend is reading through IVECO. And Mr. Beale for HMRC stands up and asks my learned friend to read an additional paragraph. And then Mr. Cordaro carries on reading, and it's the paragraphs that my lady today also pointed out to my learned friend, that basically the judgment of BTCA in relation to the 9-month claim. And then if I could just pick it up, it's just a few lines on page 67, from line 7. This is Mr. Cordaro. The reason I wasn't going to read any of that out to you is it's completely beside the point for today. Because if you look at the dates, first of all, it's all pre the enactment of Section 24, which brought in what became Section 80. And it deals with the period before the bad debt relief system was enacted. I add there the 9-month period. So it deals with a short period, where we were, in a sense, in the UK in a state of nature. Article 11C1 had come in the Sixth Directive 77 with effect from January 78. The UK took a bit of time before it enacted bad debt relief. It took another 10 years before it enacted Section 24. But we're not concerned with that initial period. We're concerned with the period covered effectively by Section 80, and we have got permission to run our common law arguments for that very early period, because, I just add here, because, of course, I didn't win on issue 3. The trouble is, there's very little money in it, so his lordship was quite right when he said, good luck with your common law claim. He was wrong when he said it was 6 years only, because perhaps he didn't anticipate it was going to be a mistake-based claim, which has the Section 22, that's a misrecording by the transcriber, 32(1)(c), extension to it. But that couldn't have been known until Deutsche Morgan Grenfell in 2004, but I've read it. And then it goes on to deal with IVECO. So my learned friend chose not to press the obvious point, the IVECO Section 80 point in the statutory appeal, and this led to the conclusion in the statutory appeal from the Upper Tribunal. which I went to yesterday, but I can just. I'm sorry, I forgot that we were over the lunch period. I'll just give the court the reference. It's volume 7, tab 64, page 1942, para 65 of the Upper Tribunal 2023, which, to summarise, says the nine-month claim came under the old scheme with a 6-year restitution. Came under the old scheme, or was a restitutionary claim with a 6-year limitation period. And then there's a general Section 80 has no application. So if my learned friend is allowed to go on, we don't see how he can say, because of IVCO, I paid an amount to HMRC not due to HMRC. And that was that founds unjust enrichment. Because that would be, of course, IVCO was a Section 80 case, it would be a Section 80 argument.
And there's
an
ouster. Well, Section 80 has an express ouster.
Under subsection 7. And that's why we say in our respondent's notice, again, can I just give the reference? It's at core page 81, paragraph 20 and 21. Did I say that right? Core bundle, page 81, paragraphs 20 to 21, while we referred to, and in our skeleton, how's IVCO going to help, given it's a Section 80 claim with the sting in its tail? As in
okay, so to summarise, you say Section 8, for the 9-month period, Section 80 was not pressed in the statutory appeal, meaning in practice the most recent version of it with the Upper Tribunal this year. This argument, if accepted, would in fact engage Section 80 with its ouster. Have I understood that?
Yes.
Correctly.
But if my learned friend wants to say in the 9-month claim period, IVCO applies, with that comes the baggage, IVCO applies, I've got a Section 80 claim.
Which is already lost. Has he? Or not?
On the ouster? Sorry, I didn't understand.
Has he already lost his Section 80 claim for a 9-month period?
Well, A, he didn't press it, and B, we have the conclusion of the Upper Tribunal, Section 80 has no application, which yes. I will say means he's lost it, because it's a Section 80 has no application across the board.
But quite separately, this court can look at Section 80 and the express ouster provision in it, in deciding whether a common law claim. I mean, that's a separate point, isn't
yes,
it?
my learned friend will say that,
yeah.
Well, have you said enough to plead a Section 80 subsection 7 ouster? I say I have. See 17 of our defence and see paragraph 20 and 21 of our respondent's notice. But also see Upper Tribunal 2023, where it's by not pressing it in front of the Upper Tribunal and having a conclusion that Section 80 has no application, it brings the 9-month claim into the same position as the main claim, because I can say again, we've got a finding now from the Upper Tribunal 2023, Section 80 has no application. So, and I'm very conscious of time. 32(1)(c), I was just going to mention Becker, where it was said that the 1980 case, it's in our skeleton, we don't need to turn it up, but it's the Becker case that said if a member state doesn't implement a directive, then it's got direct effect. 1980. So for the 9-month claim, when there was no implementation, Becker told you the answer. If you still had some doubts, and this is a point my learned friend can make, you still have some doubts because of that second part of 11C1, which allows derogation in the cases of total and partial non-payment. That's why Goldsmith becomes important, because
it says you can't just not do it.
It says derogations have to be justified.
Yes.
So.
Yep. That I think
that's how I answer the 9-month claim. very conscious that I've taken up the lunchtime, so I don't have anything further unless there are questions.
No, we have no further questions.
Cool.
Thank you.
For sitting late.
Thank you both very much for your very comprehensive and well-argued submissions. We will, as you won't be surprised to hear, reserve our judgments. As is now standard, you will receive a draft of a judgment. As you know, it comes with an embargo, which means what it says. And that is the opportunity for you to correct our grammar and spelling and not to re-argue the case. And then the final judgment will be handed down remotely with no attendance, in the hope that you will be able to agree an order giving effect to our final judgments, but if not, we will resolve any issues on the order on paper. Thank you all very much.
All rise in able.